Two roads diverged in a yellow wood, and sorry I could not travel both. And be one traveler long I stood, and looked down one as far as I could, to where it bent in the undergrowth. Then took the other just as fair, and having perhaps the better claim, because it was grassy and wanted wear, though as for that, the passing there had worn them really about the same. And both that morning equally lay in leaves no step had trodden black. Oh, I kept the first for another day, yet knowing how way leads on to way, I doubt if I should ever come back.
And the librarian at that time, he said, "Mary, the best thing that can happen to this school is if you fall flat on your face."
But when I think Ralph probably maybe wrote about this, but when I raised the questions of status in the ABA rules, they disbanded the committee.
Well, finally someone turned to me and said, "Hi, have you read any good books lately?" As if I had something wrong with my hearing, or more likely my intellect.
And I'm not going to mention a name, but a dean spoke after me, and he got up and he referred to me as the Little Legal Writing Lady, and said that, if we listen to the Little Legal Writing Lady, the next thing she'll be asking for is tenure for all the janitors.
Legal writing programs have been in existence in some form or another since the late 1940s and 1950s, but not in their current form. The earliest type of legal writing course was a legal bibliography course, a course in which students were introduced to research sources that enabled them to find cases and statutes. Some schools offered legal methods courses that introduced students to legal analysis. It is generally agreed that the first legal writing courses combining at least some form of writing and analysis skills were offered at the University of Chicago. Northwestern soon after developed its own legal writing course. These courses were often taught by third-year students or recent graduates under the supervision of one faculty member.
When I first got into legal writing, the course was taught, if it was taught at all. Schools didn't have to have a legal writing course. If it was taught at all, it was taught by third-year students. This was the prevailing model. Third-year students supervised by the law library. And gradually, some schools hired full-time teachers, most of whom had just graduated or had been out in practice for a year or two. And this was considered a transient job. You would take it for a year or two and then go off and do something else. The assumption of doctrinal faculty is that no sane person would do this for any period of time, because doctrinal faculty were under the impression that it was so much work that people would just not enjoy doing it. They'd get exhausted.
The early legal writing classes were enormous, were often given little or no academic credit, had disparate coverage, and were frequently graded on a pass-fail basis. Although it was generally accepted that full-time librarians would teach legal research courses, many faculty members objected to the inclusion of organized legal writing programs and the hiring of full-time instructors to teach the course. During the 1960s, many of those teaching legal writing were adjunct instructors and third-year students, with a few exceptions, including Marjorie Rombauer and Ralph Brill. Those who taught full-time often had caps on their contracts.
See, originally, deans looked at legal writing teaching sort of like judicial clerkships. You're in for 1 year, maybe 2, and then you go. So it was an incredible turnover in persons. I'm just amazed that we stuck it out.
Marjorie Rombauer, who was the director of legal writing at the University of Washington, was one of the first directors to be able to eliminate caps in her program.
Developed my own theories about how it should be done, and most particularly I thought we should have full-time tenure-track teachers, and that was revolutionary. It took me a number of years to reach the goal, and we had 5 full-time tenure-track assistant professors teaching.
Marjorie Rombauer also self-published the first widely available legal writing textbook in 1970. Other early books used by legal writing professors included texts by Gertrude Block, Brandon White, George Gopin, and Dernbach and Singleton. For those in the field at the time, the exchange of information was limited to a link with the AALS section on legal research.
The ALS meetings up to that time, I guess there was just 1 or 2 before the 1980, the January meeting, had much smaller agendas. I know the first one that I went to, and I was on a panel, was talking more about the links with the clinics, of legal writing with the clinics. So those original ones didn't have a whole lot of pedagogical stuff for us to use. After that, of course, we did a whole lot more in our meetings, in the ALS meetings. The section was the only thing that we had, the ALS, until the LWI got going. And we all linked through that section.
The section was dominated by law librarians.
The first time that the AALS had a section devoted to legal writing and research was in 1973, which was quite late given the fact that the AALS had been around a long time. And it was a woman who was the librarian in Connecticut at the law school who petitioned the AALS to have a special section. Her name is Shirley Beisowitz, and she really doesn't get enough credit.
In 1980, Marjorie Rombauer, along with Norman Brand of Albany Law School, petitioned the AALS to change the name of the section to Legal Writing, Reasoning, and Research. Following the AALS meeting in January of 1980, a group of legal writing professors was able to hold an AALS-sponsored workshop in Louisville, Kentucky. This core group included Ralph Brill, who 2 years previously had created a 3-year legal writing program at Chicago, Kent, and Marjorie Rombauer. In attendance was Mary Lawrence, who had become the director at the University of Oregon the same year that the Chicago, Kent program was created.
This was a real coup for legal writing. I mean, a real coup for legal writing. And it was thanks a lot to Ralph. But the ALS gave very few workshops. And you have to, apply to get a workshop. And legal writing was in its infancy. And so for them to put on a full-fledged workshop in Louisville, Kentucky, that was something. And that was pretty much a seminal time for a lot of people. Ralph was at it. Marjorie Rombauer was at it. And I remember thinking, oh, these people, how wonderful they are. I would like to be like them.
Yeah, exactly.
Exactly.
Right.
Chris was there, Grace Tonner was there, Helene Shapo, Marilyn Walter, and a whole bunch of us who miraculously have stayed doing this.
4 years later, Christopher Rideout from the University of Puget Sound School of Law brainstormed with program director Laurel Curry Oates about what could be done with the remaining money from a National Endowment of the Arts grant. They decided to hold a conference at Puget Sound that would cater exclusively to legal writing professionals.
some extra grant money, not enough to do a conference, but some money, and it was like, it would be really nice to figure out who else is teaching legal writing and what it is they were doing, and it was like, let's send out some invitations.
Laurel and I approached Fred Townsend and we said, we want to have a legal writing conference. And he said, that's a great idea. How are you going to pay for it? And we said, well, we have $3,000 left over from this grant, and we'll charge people a modest registration fee to come. And he said, go for it. I think it's a wonderful idea, and the only thing I want to say is that if you go over budget, said this to Laurel and I, you two are personally liable.
Conference proved to be such a success that the unofficially named Legal Writing Institute was determined to host more conferences. This aspiration became a reality when, less than a year later, Ralph Brill organized a second AALS legal writing workshop that was held in Chicago. Following the workshop, several veteran members of the profession met and incorporated the Legal Writing Institute. Shortly thereafter, the Legal Writing Institute began various endeavors, including publishing a newsletter. The newsletter, which was eventually named The Second Draft, was edited by Ann Enquist during the early years. In 1990, LWI created and distributed the first survey, the brainchild of George Gopin and first initiated by Jill Ramsfield. In 1994, the Legal Writing Institute Conference was held at Chicago-Kent College of Law. As part of the conference, Ralph Brill set up an in-house computer communication system so that conference participants could contact each other electronically. The system was continued beyond the conference and became the Legal Writing Listserv.
Because I remember the day that it was installed and that I was signed up for the listserv, and I went to class and I came back and it was live. And I turned it on, and there was the list of messages. I was like, oh, here are all my friends, and it was just a wonderful opportunity to communicate and to get help and get advice. So it was so egalitarian, and I think it promoted. I say that I would not have tenure right now if it were not for the listserv.
After the conference in 1994, Jan Levine spearheaded an effort to organize the directors of legal writing into a political force that would lobby for changes in status and security. In 1995, the directors held their first conference at California West and afterward voted to form the Association of Legal Writing Directors.
The problem with teaching legal writing is the work is wonderful, but you're constantly being told that you have to be dumb to work this hard. And it can be really difficult to hire good people and watch them be mistreated in the academy and not be given the rewards that they should be given. So OLWED became an opportunity to try and change these status matters.
Aside from advancing the political objectives of the profession, the ALWD also challenged the norm for law school citation usage by publishing its own citation manual, with proceeds going to fund scholarship grants for legal writing professionals. Both ALWD and LWI publish peer-edited journals whose articles are often cited by judges. On the political front, the mid-90s saw various members of the profession fighting for a change in standards in status. Ralph Brill, Helene Shapo, Richard Neumann, and Susan Brody were instrumental in lobbying the ABA to adopt standards that enabled the profession to move forward.
But there was this core group of us. There was maybe 20 of us at the time. I can name it. It was Ralph and me and Chris Kunz and Helene Shapo, and there wasn't many of us. Maybe Helene was chair before. I can't remember. I don't want to fail to give anyone credit for how this happened. But and that committee ended out being one through which we really marshaled some heavy political movement. This was also right after the clinicians had been really successful in marshaling and getting the 405, status and really fighting that great hippie rebellion that they had. And we decided, well, the way we were going to get more people better status was to really band together with the clinicians who really helped us a lot. One clinician in particular who we met was also a legal writing person, Richard Neumann.
The ABA has its annual meeting in August, and for some bizarre reason they wanted to hold it in Orlando. So we all go down there. Ralph and I are wearing suits. Watching me in a suit is something very few people have actually done, but because for me, ordinary clothing is a Sears work shirt and be a pair of blue jeans. So I had to wear a suit, and I went down to Orlando. Susan and Ralph and I meet up, and we lobbied this. We had no idea how to do it. We didn't know what the politics were, but at the same time, Roy Stuckey and the clinicians were lobbying the standard on job security, and we weren't sure what we were lobbying. We were working on that standard, trying to get legal writing teachers into it, which I think we did not succeed at. Or we might have gotten something in that was so innocuous it didn't really accomplish much. But we did get something in the curricular standard, which is 302. 405 is the job security standard. And we came back exhausted. We didn't accomplish what we had set out to do, but we accomplished something. And this was the first time that legal writing was in the standards. And that was a kind of watershed.
Brill, Brody, and Neumann then partnered with Chris Kunz and Marilyn Walter to write the first legal writing sourcebook, a project sponsored by the American Bar Association. The sourcebook provided valuable information about optimal legal writing programs and has been used frequently to influence administrators to make improvements in their programs. The second edition of the sourcebook was published in 2006. In the last decade, the field of legal writing has grown exponentially, with many schools affording legal writing professionals the opportunity for status and security. Those wishing to make legal writing their careers now have hope for advancement and treatment on par with the tenured faculty. Unlike the early days when there were no resources for legal writing professionals, there is now a plethora of textbooks and scholarship. It is also rare that law schools treat their programs as non-essential or unworthy of credit. Rather, many legal writing programs are now the focal point of their school's curriculum. In 2004, Seattle University handed over the reins of the 20-year-old Legal Writing Institute to Mercer University School of Law. In 2006, Mercer, along with other schools in Georgia, hosted its first legal writing conference in Atlanta. Now, more than 2 decades after the formation of the Legal Writing Institute, it is acknowledged that there is still much work to be done, but it is hard to ignore just how far the profession has come since its early days of perpetual fights for survival. It is also impossible to ignore that those involved in the profession of legal writing have been involved in a rare phenomenon that combined the vision of a few with the drive and determination of many selfless individuals working for the benefit of everyone.
Was a different personality that likes to go into legal writing. And I have been blessed with the best colleagues, you know, in legal writing, in the people that I've worked with, because we've all learned from each other and we have all supported each other. It's like being in the trenches together. It's a real bonding experience.
So I'm thrilled to still be in legal writing. I'm thrilled to keep working with people who come into legal writing. I'm thrilled to be working with faculty members who are willing to teach legal writing. And I am thrilled that what began as a very modest conference in 1984 with the Legal Writing Institute has blossomed through really the work of my colleagues across the nation into the amazing organization that it is.
Difference to me. That's a fascinating set of people to hang out with. They're also really nice people. It's a great community. It's my longest friends in the academy.
I shall be telling this with a sigh somewhere ages and ages hence. 2 roads diverge in a wood, and I took the one less traveled by. And that has made all the difference.
The great regret of my life is that either they hadn't started earlier or I had hung on longer so that I could have had that kind of support